Hello and welcome to my presentation. The Site C Dam project is chosen for this case study to demonstrate the colonial barriers that Aboriginal peoples in Canada are facing when they argue, claim, and maintain their Aboriginal and treaty rights to the land. Site C is a development project of a hydroelectric dam and generating station in the Peace River region of northern BC. The completion of Site C involves the flooding of 5,500 hectares of Treaty 8 land. Treaty 8 First Nations against the project point out that the construction of Site C will have adverse and irreversible effects on the traditional land. The alteration to the environment permanently changes land usage, which interrupts deep cultural and spiritual connections between First Nation peoples and the natural and ecological features of the land. The signing of Treaty 8 began in 1899. The public notice here shows the initial scheduled dates for signing. First Nations in northern Canada felt the need to negotiate a treaty with the Crown when oil and mineral resources were found there in 1891, leading to the increased arrival of settlers and miners in the region. At present, the conflict at Site C remains one that involves land and resource extraction. Treaty 8 is the first numbered treaty drafted by the commissioners in their own tent after having meetings with the chiefs and headmen of the First Nations. The initial drafting used the Prairie Nations as reference, where agriculture is a feasible way of living. Northern First Nations were especially concerned about the ability to maintain the unique ways of life in their homeland, which include rights to hunt, trap, and fish. First Nations on Treaty 8 land only agreed to sign after the commissioners guaranteed that the treaty would not lead to any forced disruption to the traditional ways of living. Despite First Nations saw the treaty as a peace and sharing agreement between sovereign nations rather than a surrender of title, the Crown's version of the treaty included a clause that subject the right to traditional ways of living to regulations by the government. The Dainsa, known to the Europeans as the Beaver people, traditionally lived in small nomadic hunting groups of 25 to 30 people. The photo shown here is taken from the film Modest Livelihood made by Dainsa artists. The film shows a series of moose hunting trips in the piece to demonstrate that hunting remains an important activity for their well-being. The guarantee of hunting, trapping, and fishing rights is crucial to the Dainsa in upholding their opposition against the Site C project. Chief Roland Wilson of the West Moberly First Nation, in a letter to Attorney General David Eby, called Site C a denial of treaty rights, and he referred to this particular guarantee in Treaty 8 that protects their unique ways of living. Elder Lisa Wolf of the Prophet River First Nation asserts that Site C will have severe impact on future generations because the development plucks up water, which challenges their future existence. Aboriginal communities in Canada often need to work through complex legal systems and different levels of government when their constitutional rights are violated by major resource projects. On January 15th this year, West Moberly and Prophet River First Nation filed civil suits against BC Hydro, the Attorney General of Canada, and the Province of British Columbia for violations of treaty rights. Few weeks later, the West Moberly First Nation sought for an injunction in the provincial court to halt construction until the pending treaty right challenges are resolved in court. On February 16th, logging contractors were stopped by the First Nations from clear-cutting, and BC Hydro suspended logging along areas identified by the First Nations as culturally and ecologically critical to allow for orderly resolution of these legal issues. About a year prior to the filing of civil suits against the infringement of treaty rights, the Federal Court of Appeal dismissed the First Nations' application for a judicial review on the environmental assessment process that informed the approval of Site C construction. The panel of judges denied the application on grounds that the Crown has fulfilled its duty to consult, and the environmental assessment is an information-gathering process rather than an evaluation of whether the project violates treaty or Aboriginal rights. Meanwhile, in response to the upcoming injunction hearing at the Provincial Court to halt Site C construction, the federal government announced that it will take no position while the BC courts decides if the project violates constitutionally protected treaty rights. The injunction hearing will be heard from July 23rd to August 4th. The recognition of Aboriginal social organization in the terms of Treaty 8 is important, as we have seen in Chief Roland Wilson's letter, and the ability of West Moberly and Prophet River First Nations to support the claims using these terms. Treaty 8 allows First Nation to argue the case not only based on land title and resource ownership, but also by the evidence of direct interruption to traditional social organization. The Crown should respect that a treaty signifies nation-to-nation relationships. Meaningful reconciliation between Canada and Aboriginal groups requires the Crown to respect treaty rights, and in this case it is the right for the Dainsa to maintain the traditional ways of life associated to the land that is designated for Site C construction. The runaround between different levels of government and the Canadian legal systems, all of which are appointed by the Crown, represents the colonial barriers that Aboriginal peoples are facing when they assert their rights as unique sovereign nations. It is dishonoring of the Crown to deny rights that are guaranteed in a treaty. The photo here shows some of the damages of Site C construction to the beautiful Peace River Valley. For more photos, please visit the link to Narwhal. The destruction caused by Site C, as Elder Lisa Wolf reminded us, is likely to have adverse effects on future generations. Indigenous connections to the land often inform the shaping of Indigenous knowledge and Aboriginal identities. Irreversible changes to the land directly challenge the well-being of Aboriginal peoples. In fact, Helen Knott, a Dainsa of the Prophet River First Nation, connects violence against the land to violence against Indigenous women living in the Peace. I encourage you to watch the CBC interview with Ms. Knott to learn more about the devastating effects caused by violence against the land. I would like to end the presentation with a poem written by Helen. This place in which was created for us gives us little choice but to stand. It is where silence is not favorable, because silence equals erasure, equals invisibility, equals death. My voice, our voice, the people's voice is life. Thank you for viewing.